submissions in volume 2.4, which your lordships had yesterday. We'd also given hard copies. I'll go very quickly because I've covered this ground. I just want to quickly run your lordships through the point. Internal page 19 of that, running page 22. I brought the Sikkim case to your lordship's notice under 14, 15 and 21. All three. Then at page 19, para 58, your lordships in Puttaswamy have also categorically held that the right to freedom of religion under 25 has implicit within it the ability to choose a faith and the freedom to express or not express those choices to the world. And these are an illustration of the manner in which privacy facilitates freedom. Then in the same judgment, your lordships have held at page 20 that the freedom of belief or faith in any religion is a matter of conscience falling within the zone of purely private thought process aspect of liberty, and that privacy is essential to the right to profess, practice and propagate religion within Article 25. And in Shafin Jahan's case, your lordships have held choices of faith and belief, including in matters of marriage, lie within an area where individual autonomy is supreme. So the right of decisional autonomy is well recognized as part of Article 21. In Kaushal Kishore, your lordships have noticed that several rights, including 25 and 26, have horizontal effect. They are not only against the state. Now comes to the questions my lords were posing to me yesterday about the scope of judicial review, because I think I must clarify that very clearly what my position is. It's not exactly the same as the learned Solicitor General, but it's also not an extreme position. I'm trying to tread a middle path. And it is this, if my lords would kindly see, I have actually set it out at page 29 of my supplemental submissions, para 82. Sorry, before that, may I go to para 63, page 22? I've just broadly summarized what is ring fence, what judicial review, where judicial review should not, as a matter of practice, be.
Explain this to the concept. Kishore says horizontal effect.
Yes. No, that would mean that it's not available only as opposed to state action, but one can propound the right even independently of state action. That is broadly what is held. And as I told my lords, under Article 226, your lordships have recognized the right against a public charitable trust. So as long as there's a public charitable trust, these rights can be propounded. In my case, there is a public charitable trust. But just, if my lords would see page 22 at para 63, now these aspects, I believe, should be ring-fenced. Let me be very, very plain. I don't want to, my lord. The first is, if a practice or a belief, but a practice even, is proved undoubtedly to be the belief of that community or denomination, a judge is bound to accept that. But that proof has to be there. And your lordships have described that in various ways. Shirur Mutt itself said that of that there would not be judicial review. Bijoy Emanuel said, and I've said this out at page 22, the court would certainly determine whether the belief is genuinely and conscientiously held as a part of the profession or practice of religion. So if the court is satisfied that that practice or the doctrine, based on doctrine, text, whatever it is, has been established and that is a genuine establishment, then deference, I believe, should be shown.
Mr. Khambata,
yes.
Is your quoting of Ratilal Panchanand Gandhi correct?
Yes.
They proved undoubtedly to be the belief of the Zoroastrian community. A secular judge has the word secular in the.
It has that. It refers to an old case, an old Bombay High Court judgment, where someone had left an endowment under his will.
No. They are qualifying a judge as secular in a judge.
Yes. I'll check that again. I'll have it checked, but I think it is there. It is there. I'll check it again. It is there. It's very old. Your lordship is right. Secular meaning someone apart from religion. Any constitutional court would be apart from religion, therefore, in that sense, secular. Now, there are two areas which have always been the subject matter of judicial review, and that I've covered in para 64 and 65 and 66. One is where there are competing doctrines or points of view within that religion. In fact, in my case, that's might arise definitely. But there your lordships have held in the Tilkayat case, which is the Nathwara temple case, that and I've just quoted that section at the bottom of page 22, in cases where conflicting evidence is produced in respect of rival contentions as to competing religious practices, the court may not be able to resolve the dispute by a blind application of the formula that the community decides which practice is an integral part of its religion, because the community may speak with more than one voice, and the formula would therefore break down. This question will always have to be decided by the court, and in doing so, the court may have to inquire whether the practice in question is religious in character, and if it is, whether it can be regarded as an integral or essential part of the religion. And the findings of the court on such an issue will always depend upon the evidence adduced before it as to the conscience of the community and the tenets of its religion. And then in Adi Saiva's case, just the first two sentences I'll read. Often occasions will arise when it may become necessary to determine whether a belief or practice claimed and asserted is a fundamental part of the religious practice of a group or denomination making such a claim before embarking upon the required adjudication. A decision on such claims becomes the duty of the constitutional court. So the first step is it proved to be unequivocally part of the doctrine of the religion? And is there any conflicting view? No. If we reach that position, then a court should show judicial deference. Because it's not for a court to sit in judgment about the correctness of a practice or the rationality. That much, I think, is clear, and I don't think your lordship should interfere with that part of the law which has been well decided. Now, I have attempted at page 29, para 82, it's come in the wrong place, unfortunately, it should have come earlier, to set out which are the areas of judicial review that could potentially arise. Para 82, at internal page 29, the running page 32 in the volume.
Yes. Running page 32, internal
29. In my respectful submission, judicial review will be imperative in 6 areas. One is whether or not the doctrines of a religion include a particular practice. 2, whether practice or belief is a genuine practice belief enjoined by that religion and not an artifice. This is based on certain language used in the judgment. Now, this is a judicial review only to ascertain factual genuineness. Is it genuinely a part of that religion? Once that takes place, then the courts, in my respectful submission, should step back and not get into a judgment on whether it's a valid practice or a rational practice or whatever. But then 3 onwards still remain. Whether a current organization or entity has the exclusive right to dictate what the doctrines of a religion are. Because you'll have, in my case, the trustees of this very trust earlier were allowing intermarried women in. Suddenly there was a change and the new one said no. That can't be a practice then. That's a personal predilection. Then 4, if there are conflicting doctrines or practices, then which of these is part of the religion and which not? 5, whether a matter of religion or a practice doctrine is contrary to public order, health or morality, that is in the article itself. And 6 is what I'm coming to now. Whether a practice of religion in a particular instance collides with a competing fundamental right under 14, 15, 21, 25(1). If so, then how the doctrine of balancing or harmonious construction or double proportionality is to be applied to save the precise interests or core of both competing fundamental rights. To that end, the precise interests or core of the religion will necessarily have to be determined. I'm coming straight to that.
But the difficulty for us is this. Now you are asking us to get into an arena where you are, we have to adjudicate upon the rights of A against B. It is not, according to, as rightly, you rely upon Kushal Kishore and say, normally when you define a non-state actor, it will be an unknown face.
Yes.
But what you are actually contending and expanding that to mean a member of the denomination who is not in agreement with the religious practice, can you actually question the religious the denomination's right? How does that come within the purview of the judicial review of a constitutional
I'm obliged.
court?
That is the
It
key
may be a
question.
case for you to file a suit or anybody.
No, that is the key question.
But,
My lord is right. That's what I'm trying to,
now, we are only conscious about our own jurisdiction. Once we
Undoubtedly.
open it up,
and that's a good.
where do we end? And we'll be having thousands and thousands of cases of
No,
this
no.
nature.
For the respondents in the writ petition,
Yeah.
The respondents are the trustees of a public charitable trust who administer
So Kishore,
place of
suppose
worship.
that they won't come under Article 12.
But 226 will lie, that your lordships have held.
Of course,
Kishore says that right, but that constitutional right can run horizontally as against the person on the premise that person is not exercising his own right under the constitution. All right, if a violator, if B violates like Article 17, you can take. If somebody violates it, you can always say that it is violated. But when somebody claims it as his right,
May I suggest,
the constitution,
may I propound
to adjudicate upon
may I propound
rights
an example?
on a disputed factual premise.
No. I accept what's
regard to
falling.
Article
I accept.
17, there is an act.
Yes,
There is an act which is made pursuant to Article 17.
yes,
And under that, the disputes are adjudicated.
yes. That would be also.
Yes.
That would be also.
Civil Rights Act.
But I make it very clear, that if there is,
In the,
Yes,
in the simplest terms, question number 1 to 4,
Yes.
out of the 6 which you have formulated,
yes,
are essentially 1 to 4 are predominantly question of fact. Predominantly,
yes,
and 5 and 6 are the legal consequences.
my lord is right.
So what my brother and sister have pointed out is that what should be the form? Because if it is a question of
understand.
fact, then it would require,
A civil suit.
it would require evidence. So
But
probably we are, maybe that to that extent impliedly, probably we also might be inclined to agree that the issues would require judicial adjudication.
yes,
The question will come only of the form
my lord is right.
and the substance.
I am obliged to my lord because that would be a correct formulation. There will be cases and cases. And again, not because I want to cite the facts of my case, but my case is a good example to give. In my case, no practice has been set up because, in fact, we have produced letters and resolutions from various Parsi Anjumans all across India saying we always allow women in.
We are on general principle.
General.
Your case,
So, in a given case, a practice may not be set up. That's what I'm saying. I'm saying mine is only an example. There may be, to start with, not a practice. Then a court has to look at the trust deed and say, does the trust deed permit you or not? That's all. Therefore, there will be cases and cases.
So, and secondly, whether this ban on the lady marrying outside the religion, whether is it a matter of religion?
No, I can unequivocally say it is not. And let me put it another way. The High Court itself has found that even a Parsi lady marrying outside retains her religion. As a matter of fact, that's a finding of the High Court. And they said no material is put before us to show even a non-Zoroastrian cannot enter. Now, I must say, in fairness to the other side, before your lordships, they produced a whole lot of material and we've countered that. I'm not getting into the facts of my case, but my lords may take it that there's nothing in the material they produced which at all shows that there's anything in the religion which somehow prohibits, ostracizes, or excommunicates only a Parsi lady for intermarrying. They have relied on certain texts, which also is wrong, because if you read the actual text, which they've given the translation, it doesn't say what they've said in the submissions. But the highest case is the intermarriage is frowned upon. But they don't meet the elephant in the room, which is then how do you allow intermarried men and their children in? So that's a matter, these are certainly areas for the court to go into. Otherwise, any institution will get up and based on the personal predilections or even sincere beliefs of its trustees say, no, you can't come in. Then the next set of trustees say, all right, you can come in. That can't be a means of exclusion, is all I'm saying. If there's a genuine established belief or practice, then yes, judicial deference must be shown.
Question put forth by Honorable Chief Justice.
Yes.
See, so far as your case is concerned on merit, prima facie, we find something.
Yes.
But what would be the forum then? If it requires an adjudication, like you were saying, the trust may take a different stand today or tomorrow, they may rely upon something, same change. But can we go into the, see, that factual adjudication?
No, my lord, I agree with my lord. If someone,
So, will a hard case make a good law?
yes,
Or in your soft copy submissions, you perhaps dealt with this issue saying that these issues, the power under Article 226, maintainability is not in doubt, but entertainability is
Yes.
completely with the
Yes.
court,
of course.
depending on the nature.
I
of the
bow to
offense of
that.
the-
I bow to that completely. There's no
No, I
question.
think that, I'm
Yes, I have.
gathering it from your.
I have, my lord is right.
Mr. Kumar,
I'm not, I want to just clarify if I gave any wrong impression. Of course, that's within.
Like, are you saying that the practice which should be uninterrupted being followed for a long period, not subject to somebody who is managing the affair of a denomination?
That is one point,
If
my lord is right.
that is at the
Yes.
will and wish of somebody managing the denomination.
Yes,
And it changes as per there is a change, there is a practice change in the practice, or there is an interruption in practice, then such practice is not necessarily a practice, religious practice or essential religious practice being followed uninterrupted.
my lord, please.
And their court can,
My lord.
the intervention of court may be subject to a
My lord,
particular
please.
case is
And secondly,
acceptable or
where indisputably the same denomination, assuming it's a denomination, different parts of the same denomination follow different practices. Also, it shows it's not a practice of the denomination. But my lord is right. These are the essential 2 points. They don't arise in most cases. In some cases they do, and I believe in my case they do. Now, my lord,
It is not a matter of religion with regard to this
That-
ban on entry. Then you can always seek a civil relief, filing a suit.
precise. I can always seek enforcement of the trust deed because it's not a matter of, it can't be a matter of religion if some people allow, some people don't, within the same denomination or the alleged same denomination. Therefore, ex facie it can't be.
Then file a suit for mandatory injunction.
I don't need to. It's the other way around. I was always entering. If the current administration stops me, they would have to establish the exclusionary practice in a civil court. That's what the High Court also seems to
So
have.
if they stop you, then you are the aggrieved party.
I'm the aggrieved, but it can't be that the present administration manages to stop me, putting the onus on me to go to a civil court. I can understand a long-standing practice. That's a different matter. But where I have been going and people similar to me have been going, and suddenly I'm stopped, then surely the burden is on that person to establish it in a civil court. That's my submission. I place it. It can't be that
Still then,
to worship I have to,
you may require to
Spend
go
years
to a
in
civil
litigation.
court, not to get a declaration as to your practice, but as an injunction on
Injunction.
your entry.
Yes.
So an injunction suit will be, it's not a declaratory
Yes.
suit. And
But-
there, if a rebuttal is given in a written statement that
Yes.
we have as a matter of religion, this practice of excluding married women, it will become a matter in issue in the suit.
And that they would have to then
Yes. So where the
prove in
in your submission, where the High Court has gone wrong, is the presumption which has
Presumption.
been articulated against.
I'm obliged. That is my real complaint against this judgment. That presumption in law doesn't exist and it'll have far-reaching consequences across religions, not only limited. No, not.
To the relief, please see the dissenting opinion in Kaushal Kishore. Where is the relief? Because everybody reads the majority, nobody reads the dissenting. See the dissenting opinion as to where you should go for your relief.
I will certainly.
Yes.
I will certainly. Now, my lord, I come to an area which might not strictly arise in my case, but or it may arise. I'm not prejudging my matter. But it's an area that will arise in most matters if there are assertions of competing fundamental rights. And my lords put to me that we've been hearing these terms balancing, harmonization, proportionality. How do we do it? Now, the best I can offer is two judgments of your lordships and one interesting judgment only by way of example of the European Court of Justice, faced with a similar sort of situation. So page 24 of my note first, para 69, running page 27 if the soft copy is me. This is in the electoral bonds case.
Yes.
Association for Democratic Reforms. Your lordships recall the conflict there was between a right of privacy asserted regarding political donations versus the right to information and freedom of information. There were the two fundamental rights in competition. And your lordships adopted what is called a double proportionality standard. The normal one is single proportionality because you're analyzing a state action and its impact on a fundamental right. But here you have two competing fundamental rights, therefore double proportionality. And your lordships held at para 155 that the court, while balancing between two fundamental rights, must identify the precise interests weighing in favor of both competing rights. And then a four-pronged structural standard was framed, which I'll just read out. First is, does the Constitution create a hierarchy between the rights in conflict? If yes, then the right which has been granted a higher status will prevail over the other right involved. If not, the following standard must be employed from the perspective of both the rights where rights A and are in conflict. So in other words, does 26B, is it given a hierarchy or higher status than either 25(1), 21, 15, 14? If so,
This route we will be required to follow
Yeah.
only when we agree with this perceived conflict between 25(1) and 26
my lord is right. That
to
would,
be.
if there is a conflict, if there's no conflict, then it doesn't.
This word, very popularly, this word harmonize has been used. At least speaking for myself, I am not convinced that there is a need of this harmonization business here.
I understand.
There are two different kind of rights, different kind of principles.
I understand.
But you are right.
In the event,
Event of a conflict.
in the event of,
In the event of.
Only in the event. My
This
lord
is the most appropriate route
then
we
the
follow.
second is whether the measure is a suitable means for furthering right A, right B. Third is the measure should be least restrictive and equally effective to realize both rights. And finally, whether the measure has a disproportionate impact on either of the rights. And in the last stage, your lordships have held that the court undertakes a balancing exercise to analyze if the cost of interference with the right is proportional to the extent of fulfillment of the purpose. It is this step that the court undertakes an analysis of the comparative importance of the considerations
There's no
involved.
difficulty, Mr. Only point
Yes.
what we are asking is this, whether this principle can be introduced into 25(1) when you can consider the right under 25(1) between the two competing groups.
Yes.
So now, concedingly, 25(1) inures to the benefit of the group which actually professes or practices. You question it. Therefore, to that extent, they are entitled to claim under 25(1). The question will be whether you will be entitled to claim under 25(1) as against that person.
Yes.
But
Yes.
then, nonetheless, as Nalam said, still you will be able to assert your right under any other law, including the other parts of the Constitution, before by filing the suit, in which a difference may be to them under 25(1). It is my fundamental right, therefore it infringes this. But to say these two rights can be read into 25(1), to resolve a conflict there and there, it's a bit difficult for us to appreciate.
So this is an alternative argument. My first argument, 25(1) and 26 should not be read as in conflict. 26 flows out of 25(1). I'm assuming that your lordships perceive a conflict in any case.
Well, your argument is that this is the safest way.
Then this is the safest way, it is a time-tested way. And what is the right under 26B? There was a very interesting, as I said, a very short but very neat argument on behalf of the Bombay Parsi Panchayat, where your lordships were told hard cases don't go on the basis of sympathy because your heart may bleed for a particular person, but remember the right of autonomy of a denomination. Now, that's not my argument. 26B, no doubt, is fundamentally a right of autonomy from state action. That is unaffected by this. But 26B is not a right of domination. Please don't conflict autonomy with domination. Merely because there's a conflicting belief doesn't mean that religious autonomy is affected. That autonomy against the state remains. Therefore, sometimes we conflate religious autonomy with denominational control over individual members or domination. That confusion should not be there. 26B essentially is against the state, it's against state action. And a right of exclusion of an individual member will no doubt have to be established on the basis of religious doctrine. It doesn't just arise because we have a right to organize our affairs in matters of religion, or to arrange our affairs or manage our affairs in matters of religion. Now, therefore, that's the fundamental or precise interest of 26B. It's against state action. On the other hand, what is the precise interest of 25(1)? And there I do commend that the time-tested, integral or essential part of the religion, of in one or two cases, fundamental part of the religion, these are good instruments by which to balance these rights. So even if your lordships are not minded to specify the right to religion in narrow terms to start with, when it comes to balancing or proportionality, this is the only way of doing it. Because otherwise, what is an inessential practice, which is not really proven to be part of a doctrine of a religion, cannot trump the right to freely profess, practice, and propagate religion. If there's a conflict between, in the event of a conflict, that's the only submission. And I've set out at page 25 the time-tested, the trilogy, Shirur Mat, Ratilal Gandhi, and Venkatrama Devru.
Yes.
And later followed also by Sardar Swarup.
So whatever defense is available
Yes.
against the state,
Correct.
same defense they can propound against another individual also.
They can. And this is why Venkatrama Devru actually gives a very nice solution, though not in the context of other fundamental rights, in the context of 25(2)(b, because it said the exclusion is not a complete exclusion. It's only from certain ceremonies where the head of the Mat and certain members of the Gauda Saraswat Brahmin community were allowed. You're not preventing the rest of Hindus of coming in at all other times. Therefore, their right to profess, practice, worship is not that affected. Balance the two. And that therefore is a good path to keep in mind. Now, one judgment, if your lordships kindly quickly see, it's only as an example. Page 27, the judgment of the European Union Court of Justice, which in its charter, para 76, had recognized the right to freedom of conscience and religion. But a regulation was made that animals would be slaughtered only after stunning them, because that was thought to be a kindness to the animals, not slaughtering them without first making them unconscious by stunning. This was challenged on behalf of the Jewish and Muslim communities, saying this conflicts with our religious practices and rights. And they opposed stunning. Now here what the court did was to balance the religious rights which were protected by way of freedoms and this law. And they asked themselves the question whether this was an essential religious right. Was it something that was fundamental? Did it have profound personal religious importance? Was it strictly, and was the derogation from that by the requirement of stunning strictly necessary? And they balanced the two by saying, if you do not interfere with a key feature of the religion, then a regulation like this can be protected. And similarly, in para 80, a judgment of the House of Lords, where the inquiry was at the bottom of page 28 in Williamson. When the genuineness of a claimant's professed belief is an issue in the proceedings, the court will inquire into and decide this issue as a question of fact. This is a limited inquiry. The court is concerned to ensure an assertion of religious belief is made in good faith, neither fictitious nor capricious, and that it is not an artifice, to adopt the felicitous phrase of Justice Ayubashi in so and so. But emphatically, it is not for the court to embark on an inquiry into the asserted belief and judge its validity by some objective standard. That is the balancing. That concludes really my address.